Thank you. Thank you very much for joining us for today's commercial lease negotiation tactics for small business owners. My name is Jake Christensen. I'm an associate attorney at Aaron Fox, which is a law firm located in San Francisco. We are a frequent partner with the Lawyers Committee for Civil Rights of the San Francisco Bay Area and have been working with them not only to put on these negotiation workshops, but also to provide 1 hour lease consultations, which we'll talk a little bit more about, where you can get free legal advice on how to negotiate with your landlord, what your rights are under your lease, and we'll provide a link where you can sign up for one of those later on in the presentation. Like Anna said, if you have questions, you can post those in the chat box. We will stop at designated points in the presentation so that you can ask questions. I will just note that if you have specific questions about your individual situation, those might be better suited for an individual consultation. But if you have general questions about the protections, about negotiation, those are perfectly fine to ask. And so I mentioned the partnership, and also we just want to note that this workshop is specific to San Francisco. We had a workshop on the protections in the city of Oakland yesterday, and recordings of these presentations are available, so we can always provide those if you have city-specific questions, but we will generally talk about gathering your lease documents, reviewing them for key provisions, and then also negotiation tactics that are not specific to any location. And it's just important to note that this presentation is not meant to be legal advice. We're just providing information. You can sign up, as I mentioned, for one of the lease consultations, one-on-one, or you and your business partner, significant other, discussing your specific lease and legal questions that you have. And so that would be an avenue for you to actually get legal advice about your specific situation. And we'll provide that link to sign up. So our agenda today, the presentation is primarily divided into 3 sections. First, we're going to talk about the initial steps you're going to take while you're getting ready to negotiate with your landlord. Then we'll go through the relevant protections in San Francisco, and then move on to tips for negotiating with your landlord. We'll stop for questions after each of these 3 segments, and then at the end, there will be further opportunity to ask questions. So when you begin this process, you are looking to negotiate with your landlord. It's important to gather the full universe of your legal relationship with the landlord. And so that obviously includes your lease, if you have one, as well as any appendices. Oftentimes there's a lease document that's a couple pages long, and then there are exhibits or additional attachments to it. You want to make sure you gather all of those. If you are subletting your business space from someone else, you're then known as a subtenant. You would want to review the lease between the landlord and the person you sublease from, as well as your sublease between you and what we would call the master tenant who originally leased the space. And at the same time, if you have been in that space for some time and signed a new lease, you have different leases going back decades. Maybe you just send a letter that says that you intend to exercise an option to renew your lease, which a lot of leases allow for. You would just want to identify as many of those documents and put them into a central location to the extent that you can. Review that original lease and all extension documents. And we also recognize that some tenants may not have a lease. Sometimes these things are more informal. It's an oral lease. Any documentation you have about the relationship, whether it's an email, a text, canceled checks from paying rent, anything that demonstrates that there is a landlord-tenant relationship will be good to have. And so once you've gathered all the documents, your lease, the extension documents, the exhibits and appendices, you can begin to review those. And as you go through them, it can be helpful. We don't expect you to necessarily understand all the different terms and provisions, but it's good to keep an eye out for these to see if they're included in your lease, and it can help expedite the process in the consultation so that your assigned volunteer attorney can see what provisions are included in the lease and review them from a legal perspective. And so common entries in leases that include additional fees or oftentimes additional costs that are factored into your base rent include common area or other shared expenses. If there's a common hallway, if there's a shared bathroom, there's usually a CAM fee that's associated with that, or it might even be under a category known as additional rent. If you see the words abatement or reduction of rent anywhere in the lease, that's also a good provision to note. Oftentimes, if there is some sort of event that prevents you from accessing the building, or if the landlord doesn't allow you to access the building, leases will provide for abatement or reduction of rent during that period. And similarly, if the landlord were to cut off utilities, garbage collection, janitorial services, electric, heat, water, those sorts of things, those can all be potential bases for seeking a reduction of the rent that you owe. We've had tenants before where they were not going into their office because they were just working from home because of the pandemic restrictions. And the landlord during that time had taken over the space, was doing a bunch of renovations to the point that they couldn't even use it. And so, was able to pursue a reduction in the outstanding rent due while the landlord was taking over and using that space. So that's sort of a scenario where that might come into play. Other provisions, the words force majeure, which generally boil down to an act of God. There are sometimes clauses in leases that excuse performance of the landlord's duties or your duties as the tenant, which normally is to pay rent. And so if there's some sort of government shutdown or government mandated closure, we've seen leases that would provide for a reduction of rent during that period. So keep an eye out for those words. Any sort of government action, force majeure could be relevant. There are potential additional defenses, one of which is known as frustration of purpose. And when you sign a lease, that lease generally is intended to allow you to operate your business within that space that you're leasing. And given the COVID-related shutdowns, some tenants have made the argument that the lease, the contract was frustrated because due to government action, couldn't fulfill the intent of the contract, which is to operate your business. So this is an example of what's called an affirmative defense to non-payment of rent, which would mean if the landlord were to sue you for non-payment of rent, it would be a defense that you could raise that could give you a basis for reducing the amount of rent that you owe. There may be other provisions that guarantee your right to access or use the premises that you're leasing. And if any of those are tied to the landlord cutting off access, or due to government shutdown, you weren't able to quietly enjoy or access or use the premises, that could be an additional basis for seeking a reduction of rent. In San Francisco, you'll commonly see condemnation or casualty provisions in lease documents. These are often, given our history, tied to natural disasters such as an earthquake, subsequent fires, sometimes a tsunami or something if the property is located down close to water. And so those wouldn't be particularly relevant. But if you see any language for a condemnation or casualty provision discussing loss of access or use due to governmental action, that would be relevant. If you lease space in a larger food court or shopping mall where there are multiple commercial spaces on a common hallway or open space, there may be clauses that require the landlord to maintain a certain level of occupancy during set hours during the day. And obviously during the shutdowns, the landlords were not able to meet those obligations. And again, that could be another basis for seeking reduction of rent during the periods that the larger facility or that your store was not able to be open. And some of these provisions that require minimum occupancy do provide for termination rights and other rent reduction, and other rights in favor of tenants. So those can be particularly useful if you identify those in your lease. There's also something known as quiet enjoyment that is contemplated in almost every lease, residential or commercial. But the idea is that once you sign the lease, you pay your rent, and the keys are turned over to you. You have the right to quiet enjoyment of the leased space, which means that the landlord can't unreasonably interfere with your ability to operate your business there, to access the premises, that sort of thing. So keep an eye out for any of those provisions. Also note your security deposit requirements. Most leases will stipulate that you have to provide a month or two's worth of rent. Sometimes it's a separate amount not tied to your monthly rent. And then also keep an eye out for any repayment requirements. Sometimes the landlord will have the option under the lease to apply the security deposit to unpaid rent if it's not paid after a set amount of time. And then once that occurs, the tenant has a week, 10 days to repay that security deposit. So keep an eye out for those and just mark them with a highlighter or an X next to them. And there may be other defenses outside of the lease language that may be additional defenses for your non-payment of rent. And those would all be great discussion topics for a lease consultation. And it's really going to depend on what your lease says and what the specific facts of your situation are. But there may be other options out there that the volunteer attorney could identify. When you have gathered all of your documents, you have a general idea of what the legal obligations of both sides are, and what the full relationship between you and your landlord is. It's important to go into this process to try to keep an open dialogue. You want to try to remain as cordial as you can with the landlord. You're both trying to meet your individual goals of making it out of this difficult time that we've all gone through. And so you want to just keep talking, even if things get a little bogged down, or things get heated. You can take a break, but then still try to keep interacting and keep the conversation moving. We'll talk a little bit more about that during the third segment of the presentation. And at the very least, you want to just ensure that you're continuing to meet the minimum requirements of any moratorium, which we'll talk about how to do that in San Francisco. Even if your landlord's not responding, that doesn't waive your obligations to meet the qualification requirements. So you want to just keep doing what you need to do. And if the landlord or the other side doesn't respond, then at least meet your obligations for the time being. After you've gathered all the documents that we referenced and hopefully been able to review them to try to identify some of those potentially helpful provisions, you want to make sure that you're keeping copies of everything, especially if you only have one copy of the original lease. If you're going to be going to a consultation, if there is potential to need to provide copies of any of this documentation, it's just good to have extras. Also, just in case something happens, we've all misplaced something, or something accidentally gets thrown away or thrown in the recycle bin, whatever. It's just good to have extra copies if you can. If you can scan hard copy notices received from your landlord or letters so that you have backups of them. If you have emails that you've exchanged with your landlord about negotiating rent repayment or rent reduction, create a subfolder in your email account where you can keep all those in one location so they're accessible. If you have text messages exchanged with your landlord, they're not as easy to save compared to an email, but you can take screenshots of them on your phone and text or email them to yourself so that you can save them in a safe place. We've all gotten a new phone or had our phones crash, and you have to wipe it and you lose all your information. So as much of this as you can preserve as possible, it's just going to save you a headache down the road in case the worst case scenario does happen. And if you have any voicemails from your landlord, Those are pretty easily emailable, and again, can go right in that subfolder we talked about, or you can keep everything in one location. Most of you probably are required by your lease to have what's called business interruption insurance. And so if you have a policy, also gather that along with your lease documents. This in particular would be good to have for your lease consultations. There have been quite a few decisions where courts have ruled that business interruption insurance, based on the specific policies language, didn't cover pandemic-related shutdowns or business interruption. But there have been some cases in the US where courts have ruled that the specific contract or specific policy did cover it. And so it's going to be very specific on your policy and what it says. But if you have such a policy, it's something to at least look at to see if the language is helpful to any arguments that you might have. And with that, we will go ahead and take a break to see if anybody has any questions. I think we had one come into the chat. And that was just for translation. So I can pause for just a few seconds here to see if anybody has any questions. And Anna, if you see any that came in that I can't see, just let me know.
No questions as of now.
Okay. And as I mentioned, we'll have more opportunities for questions later on in the presentation. So plenty more opportunities to ask those. And you also don't have to wait until we stop. Just feel free to drop them in the chat box and we can touch on those during one of the breaks. All right, so we'll move on now to the commercial eviction moratorium protections in San Francisco. Statewide, cities and municipalities in California are permitted to extend their protections for residential and commercial tenants. San Francisco has extended its commercial eviction moratorium through that date. So based on the protections, if you have missed rent since March 17th, 2020, up until June 30th of this year, and you qualify under these business qualifications. So you have to be financially impacted by the COVID-19 crisis. You have to have registered to do business in San Francisco and have gross receipts at or below $25 million in 2019. You qualify for protection under the moratorium. This protection applies to qualified commercial tenants, as well as subtenants, month-to-month, and holdover tenants. And so if you subleased, you're a subtenant. If you have a month-to-month lease from the beginning, which just means that you don't have a 3-year or 10-year lease, it just is on a month-to-month basis, and you or the landlord can terminate it on a month's notice. Sometimes we've interacted with tenants where their lease maybe expired or ended in December 2020, but rather than move out, they just remained there. And so that lease continues to control on a month-to-month basis. Similarly, there may be cases where a tenant's lease ends and the landlord doesn't agree to any sort of month-to-month arrangement, and you're what's called a holdover tenant because you're staying in the space after your lease has ended. All of those types of tenants are protected by the moratorium. And along those lines, when we're talking about rent in terms of what you are protected from eviction for not paying, rent is not just your base rent. It includes the monthly rent, additional rent, which can include those maintenance fees and common area expenses, your security deposit, late fees, and interest. So your landlord can't say, well, you don't have to pay your monthly rent, but you do have to pay your CAM fees, or you've got to pay late fees and interest to stay current. None of those can be required to be paid under the moratorium. But it's important to note that if you still have unpaid rent once the moratorium ends, or if you and your landlord come to an agreement that gives you time after June 30th to get your rent repaid, then the landlord can begin to charge interest on the balance due. So to claim protection under the moratorium as a qualified business, it's key that you provide written communication to your landlord. And when they say written communication, it just means in writing. So it could be a text, it could be an email, Could be a formal letter, could be handwritten, could be typed, just something in writing that's telling your landlord that you are economically impacted by the pandemic. Some landlords have required or requested that their tenant provide a financial statement or a letter from an accountant about the financial health of the business, which is not something you're required to do. You don't have to provide bank statements or anything like that. You just have to, what you include in the written communication, which would be that you're experiencing economic hardship because of COVID. It just has to be what objectionably or objectively verifiable. And so if the landlord were to challenge it, you would be able to prove it. And that just means that you wouldn't want to make any wild or inflated claims, but as long as what you're saying in the written communication is truthful, that's sufficient. And this extends your opportunity to cure or pay the unpaid rent by 30 days. You're encouraged to discuss payment terms with your landlord each month, and you have to do this every month to qualify. So you have to keep up this process, keep providing written communication every month, and just repeat that. And this is what we talked about earlier with the sort of minimum actions that you need to take to protect your rights as a tenant. And all those types of rent that we went through earlier, you're not required to pay any rent as long as you qualify for each month of the moratorium, but it's important to try to pay what you feasibly can. It's going to chip away at that total that's due once the moratorium ends or your agreement ends. And your landlord can agree to extensions of your time to repay, but it's within his or her discretion. So under the law, unless the landlord agrees otherwise, you have until June 30th to repay unpaid rent. And it's also important to note that this is not any form of rent relief. It is purely a protection from eviction. So you still owe the unpaid rent, but it does prohibit the landlord from modifying any leases after March 17th. So the landlord, unless it's provided for in the lease, for example, there's usually an annual increase in rent or there's a schedule of increases provided in the lease, but the landlord can't modify any terms of the lease that didn't exist on March 17th of 2020. So if you qualify under the moratorium and you have provided the written notice, the landlord can't evict you without first providing written notice that you have not paid rent and that the landlord is going to seek eviction. Has to give you an opportunity to pay back the missed rent, which is a period of 30 days. If you are still economically impacted by the pandemic and qualify for protection, then you can extend this 30-day cure period further. And this goes back to that monthly communication to the landlord. And importantly, the landlord can't evict you for non-payment of rent while you are trying to work with him or her. So that's why it's important to keep an open dialogue, keep going to pay what you can so that you can keep these discussions open. And so it's really to your advantage to work with the landlord to come up with some sort of reasonable payment plan. And we'll talk about how to get to that point in the negotiation portion of the presentation. And since all rent is still owed, if you haven't paid all outstanding rent after the repayment period or the moratorium protections end, then your landlord could proceed with commencing an eviction action, which is called an unlawful detainer action in California, to regain possession of the premises and also to seek unpaid rent from you. So in San Francisco, we previously had a commercial eviction moratorium that was issued by the mayor. In December 2020, the San Francisco Board of Supervisors passed an ordinance that became effective earlier this year, and it created 4 tiers of commercial tenants. The first tier is defined as a business having 10 or fewer full-time employees. Those qualified businesses have 2 years to repay any unpaid deferred rent, and they also have an option to terminate by giving the landlord a 30 days written notice. All rent that is due through the termination date has to also be paid by that 30th day. but no rent due after that time is payable by the tenants. So if you are in a position where you can't feasibly continue to operate your business, your lease is not up for a couple years or a couple months, there is an option, at least as long as the moratorium is in effect through the end of June, to potentially terminate your lease early. But you do have to try to negotiate with your landlord and reach an agreement. If you're unable to, then you can exercise this option as a tier 1 tenant. If you are a tier 2 tenant, you have between 10 and 24 full-time employees, and you have up to 18 months to repay deferred rent or unpaid rent. Tier 3, which is 25 to 49 full-time employees, you have 12 months to repay the deferred rent. And if you're tier 4 with 50 or more full-time employees, all unpaid deferred rent is due the day after the moratorium period expires, which in this case would be July 1, 2021, unless it is extended. Under the ordinance, landlords can't assess any interest or late fees for rent that was unpaid during the moratorium period, and there are no penalties or fees that can be imposed in association with a tier 1 tenant's early termination of his or her lease under the ordinance. And as I mentioned, landlords and tenants can negotiate and agree to different terms that are more generous or more flexible than those provided in the ordinance. But if the parties can't agree, the ordinance controls, and the tenant can exercise, at least tier 1 tenants can exercise that early termination option. And we'll pause again, see if anybody has any questions.
Like there's any questions coming in yet?
All right. All right, so now I move on to the main event, and that is negotiating with your landlord. How do you go about doing that? And we may have both landlords and tenants on the call. I want to recognize that. And so it's important, not only from the tenant perspective, but also from the landlord perspective, to try to get each other to come to the table and negotiate. How do you do that? You want some sort of compromise that is going to appeal to your goals as well as the other side's goals. If you're a landlord, you want to get paid your rent, and ideally as much rent that is due under the lease as possible. At the same time, you want to keep a tenant in the space that you are leasing so that you don't have to turn over the space. You don't have to deal with a bunch of permitting issues to get it ready for a different use or a different tenant. And if you're a tenant, you want to stay in the space, continue operating your business. You've got a loyal customer base in your neighborhood, and you obviously want to continue to operate this thing that you've created, and in many cases have poured a lot of yourself and finances and all kinds of things into. So keeping those things in mind, you can reach a compromise that satisfies at least a portion of both of those goals. And crucial to achieving that is making an ask that is realistic, both for you and for the other side. And when I say realistic, it's really about taking an honest look at your finances, about the profit and losses that you're seeing every month. Is your business starting to rebound? Are you seeing an influx of new customers, or do you have a consistent stream of return customers coming in? How are all these things factoring into your business getting back to the new normal, or starting to bring in the kind of revenue that you saw pre-pandemic? And this is important because by making a realistic proposal or making a realistic ask, you're going to avoid setting yourself up for failure. Instead of, now that we're in the yellow tier and we can have up to 50% indoor capacity, compared to having twice as many people inside pre-pandemic, you wouldn't necessarily want to say, okay, we're in the yellow tier as of early May. I can now pay full rent beginning in June, and also pay $5,000 toward the back rent that I wasn't able to pay when we were shut down. And the reason would be if your monthly income is not close to what it was pre-pandemic, you were able to pay full rent at that time, but you weren't also paying, $5,000 in back rent. So you just want to make a reasonable assessment of what you can do so that you don't overpromise or overcommit, and then you have to go back and say, actually, what I agreed to isn't going to work, and you have to restart negotiations altogether. That's just going to make it easier for both sides. It's going to, make everybody happy, and just keep communications and the dialogue open. At the same time, don't be afraid to ask for your best case scenario. The whole point of a negotiation is to go in with your best case scenario on each side and try to come to a reasonable middle ground. If you give too much ground in your initial ask, then you're going to end up farther on the other side of the line, closer to what the other person is asking for. So really do, make a fair ask, but one that is, your ideal scenario, so that you can find something that's going to be in the middle for both sides. Examples could be abatement of rent during the pandemic, during the times that you were closed. You could ask for more time to repay that rent beyond when the moratorium ends at the end of June, if it's not extended. And you could also just ask for a repayment period that is tied to rent when you were shut down. Maybe if you were open, during that middle period between when we first shut down and reopened and then shut down again, maybe you were able to pay some rent during that time. And during the periods when you couldn't make any money because you were closed, maybe you get more time to pay that rent back compared to rent that was owed when you were open and operating. Some tenants have also worked to convert the back rent into a loan, either through the landlord, where you sort of just move that unpaid rent into a pot and you have a repayment plan for that, and then you're paying rent moving forward, either full rent or an agreed upon reduced rent. Some tenants have used some of the government loan resources that we'll talk about here in a little bit and taken out a loan to pay back the back rent. So that way you're brought up current with your landlord, and then reach some sort of agreement about rent moving forward, whether that's paying it in full or paying a reduced amount. You could also see if the landlord would be willing to credit your deposit toward unpaid rent. And that's where that security deposit provision comes in terms of when it has to be repaid. If it's applied toward your rent, that would be a way for you to reduce the amount of back rent that you owe and give you more time to pay it back once things are more back to normal. And you could also potentially consider asking for forgiveness of unpaid rent, particularly if your lease is about to end and you're considering moving spaces or staying or going. You could potentially reach a compromise where you agree to stay if the landlord waives or reduces a portion of the unpaid rent. If the landlord is not being flexible or not really giving up any ground, it's a fair question to ask if the landlord is receiving any sort of mortgage assistance. Not all landlords are. It's primarily the bigger banks that are offering different mortgage assistance programs. But especially if you're not getting any sort of concessions from your landlord, it's fair to ask that question, particularly if the landlord is asking you to substantiate why you're not able to pay rent, asking you to provide a proof of your financial hardship, that sort of thing. You can fairly ask that question, not guaranteed that you'll get an answer, but it never hurts to ask. And so in making this reasonable ask and asking for a best case scenario, again, it's important not to overcommit. And the way that you can propose doing that is to have your repayment of unpaid rent tied to the percentage of monthly revenue versus a set amount. This is, compared to the example I used earlier, where you're committing to pay $5,000 a month on top of whatever your monthly rent is. None of us have a crystal ball. We don't know sort of when our customer bases are going to start coming back, how quickly folks have moved out of the Bay Area, either temporarily or permanently. And so we're going to have folks moving back, new folks moving in, don't know how long that's going to take. But by proposing that your repayment is tied to a percentage of your revenue, that makes it so that the landlord's always going to get something. It makes it so that you're not committing to an amount that you don't know that you're going to have. So if you say, I'll put 5% of my monthly revenue toward, repaying the back rent, and I'll have 24 months to repay it. Anything that is not paid through the 3% or 5% monthly revenue would just be due in a balloon payment at the end of the period. At that point, you could ask the landlord if they would be willing to give you more time to repay that leftover amount, so on and so forth. You could similarly see if the landlord would be willing to convert your base rent to a percentage rent. And the way that I typically recommend tenants to calculate this is to look at what your revenue was pre-pandemic and divide your monthly rent by that total. And that will give you a percentage and give you an idea of sort of what percent of your monthly income went to rent pre-pandemic. You can then apply that percentage to your monthly revenue moving forward. And that will be, maybe a more doable monthly payment, at least for the foreseeable future. While some landlords have been resistant to accept this because at least right now or within the last couple of months, that has meant that the monthly rent coming in would be a little bit lower. But the flip side of that is as the customers start to come back and things continue to improve and you're selling and bringing in more revenue, then the amount that the landlord realizes from that percentage rent is going to increase. And if your business goes back to doing really well, then the landlord could potentially bring in more money from that percentage rent than they were pre-pandemic on a set base monthly rent. So there are two sides to that coin. And in the long-term goal, your business is going to be doing so well that the landlord could potentially make a little bit more from that percentage rent, but it makes it so that you're not overextending yourself in the short term. On both sides, you don't want to compromise your sanity. It's important to keep an open dialogue, open lines of communication, keep trying if you're hitting an impasse. But if, landlord threatening the tenant, tenants threatening the landlord, being verbally abusive, just, really not being helpful in the responses that you're getting, do your part to communicate as much as you need to. So send that written monthly communication. I continue to be economically impacted by the pandemic. My business is getting back to normal, but not quite there yet. I'm only able to pay partial rent this month, and here's what I can pay. And I look forward to working out a repayment plan, so on and so forth. So just do those initial monthly communications at a bare minimum. Keep in mind that the moratorium only protects tenants from eviction for non-payment of rent. If your landlord is alleging that you are creating a nuisance, that you have otherwise failed to comply with your lease, that is outside the protection of the moratorium. So keep that in mind. It's not a catch-all. It really is about non-payment of rent because of the pandemic, because of being economically impacted. We have seen some cases where landlords, despite the protection of the moratorium, are suing for unlawful detainer against tenants and claiming that they've breached the contract or committed other violations, when in reality they're suing because of the tenants not paying rent. So if something like that happens, it can be really important to sign up for a lease consultation to get your bearings on sort of what to do, how to respond, and go from there. The good news is, when that typically happens, when you actually do go to court, usually to some sort of mediation and then to trial, it will come out in the long run that really, what the basis for the eviction or proposed eviction was because of non-payment of rent, not because you were actually violating other portions of the lease. In terms of what comes next, as we've seen, COVID cases in San Francisco continue to go down. We have about the best vaccination rates of any large city in the country, and that allowed us to enter the yellow tier, which is the lowest least restrictive reopening phase at the beginning of the month. There are relevant health directives that are available at this first SF Department of Public Health website, which is a clickable link, and we'll circulate this presentation once it ends. And there's also a very helpful video on Facebook that is about an hour long, and it just provides best practices for reopening in the yellow tier, what the restrictions are for indoor and outdoor, the types of businesses, just really useful information. At this point, Governor Newsom's last executive order issued at the end of January of this year extended cities' ability to extend their commercial eviction moratorium through the end of June. At this point, given the success of vaccinations and decrease in COVID cases, we're not sure if there will be any sort of extension or additional protections, but stay tuned for that. And because of the long-standing moratoria in the Bay Area cities and across the country, a lot of the eviction cases have been on hold, at least for non-payment of rent. And so the defenses that we talked about in the beginning, looking for those key provisions in your lease, we're not exactly sure how those will shake out and how courts will view them. Typically pre-COVID, any sort of landlord-tenant dispute, the goal was to keep the tenant in the space and to work on some sort of negotiation and compromise between the landlord and tenant with a neutral mediator present, and try that. And then if the tenant still is unable to pay rent or the parties aren't able to comply with their obligations under the compromise, then the case would proceed. So there are still multiple steps, even once the moratorium expires, and if your landlord were to try to pursue eviction. I mentioned a little bit ago about business interruption insurance. Most of the cases that have evaluated those policies, they have not been favorable for the tenant, but it really is dependent on your individual policy's definition of what is a qualified business interruption. And on the off chance that your policy defines that as a shutdown resulting from government action, for example, which we see in some of the leases, there could be an argument for coverage under that policy, which would help cover some of your unpaid rent. And we have seen, like I said, some courts where business owners have been successful, one in Ohio, one in North Carolina. Those cases are being appealed, so the ultimate decision will depend on what the appellate court says and whether or not it goes up to the Supreme Court. But there's at least some success or potential for success depending on how the decisions are reviewed at the appellate level. And while we wait for the moratoria conclusion to be settled, whether it's going to be extended, while you work on getting your business back to normal, it's important to continue to research community financial resources and keep an eye out for new ones. Throughout this process, there have been funds that have closed and more funding's been allocated and they've reopened through private or federal or local government funding allocations. So even if it's not available now, it could become available again. There may be something new that is created by the city or by the federal government in terms of relief. So continue to look and apply, particularly for grants, which don't have to be repaid. And some of the loan programs like the Paycheck Protection Program also allow what was originally a loan to be converted to a forgivable loan if you meet certain criteria. So to the extent you can apply and receive as many, apply for and receive as many of those as you can, it's just going to reduce your overall burden and help you hit the ground running as you in your business try to recover. There is a very helpful page on the Office of Economic and Workforce Development for the city of San Francisco. This is just oewd.org. You can just type in SFOEWD into Google, click that link, and there's a big red ribbon that says COVID-19 resources for businesses, and it will take you to this exact page. And these are some of the examples of the financial resources that are available on that OEWD website I just mentioned. There's a list of them here and a slider that will allow you to see them, but there's a link to apply. It tells you what the different aspects of the programs are, sort of who they're meant to serve, one for restaurants, one for shuttered venues, which is Save Our Stages. So it could be an arts organization, feeder, different things like that, and tells you the total amount of funding available. Paycheck Protection Program remains open until the end of the month, which is just in a couple days on Monday. So if that's something you've been thinking about applying for, but you haven't decided yet, their time is running out for you to take advantage of that opportunity if you were still thinking about it. There are a few other programs that are in pre-application or going to be opening soon. The CA Rebuilding Fund, which are fixed low interest loans, and provide the different types of expenses that you can use the funds for. EIDL loans, which is a federal loan program, but they provide, again, low interest loans for businesses and nonprofits on a pretty lengthy term, closer to what you might expect from a mortgage. And it can just be a way for you to wipe out back rent or other unpaid expenses to kind of get caught back up. And then you have a low monthly payment that you can chip away at that pot that has accumulated during the different shutdowns. And start off with a semi-clean slate without having to try to repay on top of your monthly rent and monthly expenses. And the repayment is also deferred for the first year. So it gives you time to kind of wipe those out, give you a little more time before you have to start paying it back, and just added flexibility. And then also the SF Community Investment Loan is going to be opening soon, and it's low interest to 0% depending on the status of your organization, and up to 250,000. So if you combine several of these programs, state, local, and federal level, can really help to reduce your burden, debt burden at this time. For restaurants, there's an independent restaurant coalition that is doing different advocacy in terms of lobbying the government for additional resources and relief, great resources and ways to get involved. There are additional grant and loan programs at this OEWD website. And as I mentioned, the Paycheck Protection Program application is open until the end of this month. If you're looking for additional assistance or other resources, you can go to the Lawyers Committee's website, which is lccrsf.org. And we, of course, encourage you to apply for one of the 1-hour remote consultations. You can do so by signing up via this link. And this pairs you with a volunteer attorney. You have 1 hour of free legal advice. They can take a look at your lease, answer any questions you have, help you respond to a letter or notice you've received from your landlord. Just great way to not have to pay for a lawyer right away anyway, and get some free legal advice and help you figure out what's next as you work to grow and resume operations in this new normal. And at this point, that is the end of the negotiation section. I think we have one question here, which I'm looking at now in the chat.
Yeah, Jake, before you answer the question, I did want to share about the services. We have a legal clinic, and we actually have 2 spots for commercial lease support for clients that need commercial support. And so I'm going to send a link through the chat. We will also be having more clinics in the month of June. And so you can sign up in that same link for those as well. And it's just a 1-hour consultation with an attorney. And once you sign up through the link, you'll see it'll ask you specific questions about like what type of information we need from you. But if somebody is needing some urgent advice, I would recommend applying for the one for tomorrow. We do have 2 spots available still tomorrow, but we have more spots next month as well. I'll send that link over in the chat. Could you find the question, Jake?
Yep, I've got it. Yeah, so that's a great opportunity to get some more immediate help and advice if you're able to sign up for one of those spots. And then also, you can continue to sign up for the one-on-one consultations, which we set individually by attorney volunteer. So great resource. And again, to the extent we can save you on any legal expenses, we're happy to do that. So we do have an anonymous question in the chat. And the question is, if a tier 1 tenant requests 2 years to repay deferred rent starting today, can the landlord charge interest after the moratorium period for rent owed during that period? And so any unpaid rent up until the end of June, assuming that the moratorium expires on June 30th, the landlord can't charge any late fees or interest for any rent that was unpaid during that time, and you have 2 years to repay it from the day that the moratorium ends. And so if you have any unpaid rent left at the end of that 2-year period, you're still in the space and still leasing from the landlord could then begin to charge interest on the unpaid balance unless you reach another agreement whereby the landlord agrees not to charge interest and give you another 6 months, 12 months, however long to repay that unpaid amount. But ideally, if you repay all the unpaid rent, all the unpaid rent within 24 months after the moratorium ends, then you would not have to pay any additional fees or interest. All right, and I see that Anna posted the link to sign up for the clinic in the chat box, so take advantage of that if you are available. And I don't know if anybody else has any questions. You can feel free to pose those in the question box.
Thank you, Jake, so much for your support and sharing all your knowledge today. I'm also going to send over another link in the chat, and this is for our application. So if you're not able to make it to the clinic tomorrow, but you still want to consider support for us, our support for either a 1-hour consultation or if needed, and if you qualify for a longer term assistance, feel free to go through to the link that I just sent. I think Jake also had that on his presentation. But thank you so much for coming, everyone. We'll go ahead and share the presentation via email in a few days, as well as the recording of the presentation today. Have a great day, everyone.
Thanks, everyone.